Last week, I announced that the Senate Judiciary Committee will hold a hearing on Judge Kavanaugh's nomination for the Supreme Court starting on September 4. The hearing will begin 57 days after the President announced Judge Kavanaugh's nomination, more than a week longer than the period between announcements and hearing for the last three justices, Sotomayor, Kagan, and Gorsuch. The Senate has already received more documents from Judge Kavanaugh's time in the executive branch than we did from any previous Supreme Court nominee. We have so far received more than 184,000 pages of documents, of which more than 124,000 are currently publicly available by anybody in this country going to judiciarycommittee.senate.gov. The team of lawyers who work for the majority have already reviewed more than 10,000 pages of the 307 judicial opinions that Judge Kavanaugh wrote, along with hundreds more opinions that he joined in his 12 years service on the D.C. Circuit. The team of lawyers who work for the majority have already reviewed 110 pages of written answers and over 17,000 pages of materials Judge Kavanaugh submitted to the committee in response to its bipartisan questionnaire, the most robust questionnaire ever submitted to a Supreme Court nominee. And the team of lawyers who work for the majority has already reviewed every page of the more than 184,000 pages of emails and other records that the committee has received so far from Judge Kavanaugh's time as a government lawyer in the White House and also serving with Judge Starr when Starr was independent counsel. I expect that we will receive even more documents this very night or at the latest tomorrow, and that all remaining documents responsive to our request will be produced next week. We will work to make every unrestricted record publicly available as quickly as possible. Now, as I predicted, this confirmation process is the most transparent ever, particularly as it relates to the number of documents that we're receiving. We have already received more documents from Judge Kavanaugh's executive branch service than any nominee in history, with many more to come. And senators have more time to review Judge Kavanaugh's record than they did for at least 3 Supreme Court nominees. So I'm very confident that the committee and the Senate will have ample information and time to carry out our responsibilities under our Constitution to advise and consent. But some of my colleagues on the other side of the aisle are attempting to manipulate the American people. I just described to you the largest document production in the history of a Supreme Court nomination. But guess what the minority leader describes it as, quote unquote, unprecedented secrecy. This argument is very ridiculous on its face, and the American people aren't buying it. I got a lot of questions at my town meetings across Iowa over the last week. In 20 different counties in Iowa, this issue always came up about the Supreme Court. That shouldn't surprise anybody, but hardly any mention of this document, which is cooked up, the document issue, which cooked up by the Washington insiders. Let's not forget how this document issue started. First, liberal dark money groups and their Senate allies announced immediate opposition to Judge Kavanaugh. Some of them even announced it before the name Kavanaugh was announced by the president. The minority leader said that he would oppose Judge Kavanaugh with everything he's got. So their first tactic was to argue that the Senate shouldn't confirm anyone during a midterm election year. They attempted to invoke the Biden rule, which bars confirmation of Supreme Court justices during a presidential election year, to make this argument. Of course, this was a ludicrous position, unsupported by precedent, widely rejected by objective observers and even fact-checkers. The minority leader and his allies abandoned that argument. But they didn't abandon their goal, which is to stall Judge Kavanaugh's confirmation until after the midterm elections and hope that the other party will control the Senate. That's why the minority leader refocused his tactics and manufactured a very phony controversy regarding Judge Kavanaugh's White House documents. How do we know it's phony? On the one hand, the minority leader has publicly stated he would oppose Judge Kavanaugh's nomination with everything he's got. Now, on the other hand, he's insisting that the Senate needs millions more pages of documents on top of what we already have in order to make an informed decision. Indeed, the Senate Democrats demanded the search of every page, of every email, and every other record from every one of the hundreds of White House staffers who came and went during every one of the 8 years of the Bush administration, just because the name Kavanaugh could have been in those emails. In other words, the Senate Democrats demanded the search of every scrap of White House paper for the entire Bush presidency. As I've stated repeatedly, I'm not going to put the American taxpayers on the hook for Senate Democrats' fishing expedition. How much more information do the minority leader and his outside dark money allies need if they already made up their decision to vote no on Judge Kavanaugh? When they're in that position, they don't care about Judge Kavanaugh's record because they know what their vote's going to be. How much more do they need to know to vote no? They simply want to bury us in a mountain of paper so there's no chance that we can hold a confirmation vote on Judge Kavanaugh's nomination anytime this year. There is already a mountain of paper for our committee members to go through and their staffs. The Democrats want to make it be Mount Everest. Let's not forget that Judge Kavanaugh has a 12-year judicial track record from his time on the D.C. Circuit. During that time, he authored more than 300 opinions and joined hundreds more. These opinions provide the most relevant information for assessing Judge Kavanaugh's legal thinking and whether or not he ought to be approved to be on the Supreme Court. So I go back to something my colleagues on the other side of the aisle have said. Back in 2009, my Democratic colleagues were making this very same argument with respect to Justice Sotomayor. Of course, they're flip-flopping now. The current minority leader said in 2009 that, quote, everybody knows, unquote, a judge's record on the bench is, quote, the best way to evaluate a nominee. He said to Justice Sotomayor, quote, I want to turn to your record on the bench, which I believe is the very best way to get a sense of what your record will be on the bench in the future. Then Chairman Leahy said, quote, and this is a fairly long quote, we have Judge Sotomayor's record from the federal bench. That is a public record that we had even before she was designated by the president. Judge Sotomayor's mainstream record of judicial restraint and modesty is the best indication of her judicial philosophy. We do not have to imagine what kind of a judge she will be because we see what kind of a judge she has been. End of quote of then Chairman Leahy. Well, Senator Schumer, the same logic applies to Judge Kavanaugh's long judicial track record of 12 years. Despite this record being more than sufficient to assess how Judge Kavanaugh approaches legal issues, I requested hundreds of thousands of additional pages from his time as a government lawyer in the interest of full transparency. But even the most transparent confirmation process in history is not enough for those who decided to oppose Judge Kavanaugh before they even saw his record. The document request for Justice Kagan's confirmation provided strong support for how the Judiciary Committee is proceeding now. Then the Senate requested Justice Kagan's White House records, but not internal documents from the Solicitor General's office. We refrained out of respect for the sensitivity of internal deliberations in the Solicitor General's office. We did so even though these documents would have been extremely helpful to our assessment of Justice Kagan's views on the law, given that she lacked any judicial experience or record. And Justice Kagan herself testified that senators should look at her time as Solicitor General to evaluate her. But we didn't ask for those records. This precedent supports my decision not to ask for documents from Judge Kavanaugh's time as White House Staff Secretary. If internal Solicitor General documents were too sensitive to produce, then, of course, documents from Judge Kavanaugh's time as Staff Secretary at the White House certainly are as sensitive as well. The Staff Secretary serves as an in-box and out-box for the President of the United States. These documents include some of the most sensitive documents in all of our government, implicating our national security and other core duties of the President. These documents are at the heart of what the Constitution recognizes as executive privilege. In addition to being the most sensitive documents, they are the least probative of Judge Kavanaugh's legal thinking. The primary role of the Staff Secretary is to make sure that the President sees advice from a range of policy advisors across the entire executive branch and not provide his own policy or legal advice as Staff Secretary. So to recap, Judge Kavanaugh wrote more than 300 judicial opinions and joined hundreds more in 12 years on the bench. Justice Kagan, by contrast, had written or joined 0 judicial opinions before her nomination, despite having less need for Judge Kavanaugh's executive branch records. In light of his substantial judicial record, the Senate has already received more such documents than it did for Justice Kagan or any other nominee, and we will still receive many more. In fact, for Judge Kavanaugh, we could receive up to 1 million pages, which is more than the 5 prior Supreme Court nominees combined. Democratic leaders have also tried to argue that Judge Kavanaugh's White House records are being cherry-picked by a lawyer by the name of Bill Burke, who they label as a partisan lawyer. I guess they've forgotten how the Senate received documents during the last 3 Supreme Court nominees. Otherwise, they wouldn't have made this silly argument. The Senate received documents for Justice Sotomayor's confirmation after they were reviewed by Leslie Kiernan. She represented Obama campaign manager David Plouffe and former Representative Charlie Rangel, and eventually became Deputy White House Counsel in the Obama administration. As the Wall Street Journal pointed out in an editorial yesterday, the Senate received documents for Justice Kagan after they were reviewed by Bruce Lindsay. Now, Mr. Lindsay overlapped with Justice Kagan in the White House, which was a Democrat White House. He also served as President Clinton's national campaign director in 1992, as President Clinton's hyper-partisan senior lawyer and a real big fixer in the White House, and as CEO of the Clinton Foundation for 10 years, including when Justice Kagan was nominated. Now, I would think anybody raising questions about a lawyer by the name of Burke ought to be really embarrassed by bringing up that issue when you look at how it was handled in previous nominees to the Supreme Court by people that were partisan. So how much more partisan can you get than the people I just mentioned handling issues of presidential privilege for those Democrat nominees, Sotomayor and Kagan? Well, it happens Bill Burke is President Bush's Presidential Records Act representative, like Mr. Lindsay was for President Clinton. Mr. Burke has held this position not just recently because of this nomination. No, he's held it since the year 2009. He's a partner, it happens, in one of the most liberal law firms in America. Mr. Burke also served as President Bush's Presidential Records Act representative during the Gorsuch nomination, but I didn't hear any Democrats object to Mr. Burke's involvement in that nomination, and they didn't object to Ms. Kernan or Mr. Lindsay's involvement during Sotomayor and Kagan's nomination. Their objection to Mr. Burke's role now is another opportunistic attempt to discredit the process and to avoid talking about Judge Kavanaugh's qualifications. I'd like to correct one additional misconception before I yield the floor. The National Archives are not being cut out of this process, as has been claimed by some people. Under the Presidential Records Act, President Bush has the right to request his own administration's documents. He can choose to make a document public or claim that it is protected under executive privilege. This is precisely what he is doing now. President Bush is providing a very valuable public service to the public at what is a very considerable cost, but happens to be a non-public expense. He is expediting the review process and making sure that the Senate has all the documents it needs to conduct a timely and efficient confirmation process. President Bush and his legal team should be thanked, not scorned, for providing this tremendous service to the American people. And I want to tell you how much on top of this was former President Bush was that the day after the nomination of Kavanaugh, he called me and said, I want to do everything I can cooperate to get all the records you need to make sure that you give a fair and thorough hearing to Kavanaugh. Thanks to these people, we have Judge Kavanaugh's papers in time to hold a confirmation hearing and to vote this very year, just as the American people expect us to do. Democratic leaders have played up this phony document controversy to deflect attention from Judge Kavanaugh's extraordinary qualifications and sterling reputation as a judge of 12 years on the second most important court in this land. In these 12 years on the bench, the Supreme Court has on 13 occasions adopted a legal opinion from Judge Kavanaugh's opinions. This is an exemplary track record in the Supreme Court to have your opinions backed up by the Supreme Court, and not once, but 13 times. Judge Kavanaugh is dedicated to judicial independence. He's not afraid to tell another branch of government when that branch has exceeded its lawful authority. At the same time, he has great respect for the separation of powers and will interpret the law as it's written by the people's representative of Congress instead of trying to be a super legislator. So, I hope all of my colleagues are looking forward, as I am, to hearing from Judge Kavanaugh when he appears before the Judiciary Committee on September the 4th. I yield the floor.